Hello, I'm Sam Adair. I'm one of the partners here at the law firm of Graham Adair. In this video, I and a number of other attorneys here from the firm will be talking about immigration trends that we saw in 2022 and look ahead to what we can expect to see in the coming year. 2022 was the third year that the USCIS has used the electronic registration system to select cases in the H-1B lottery. Every year, there are 65,000 H-1Bs that are available to first-time applicants, along with an additional 20,000 that are set aside for individuals with advanced U.S. degrees. The demand each year for the last several years has far exceeded the supply of H-1B visas. We anticipate that in 2023, the demand will continue to exceed the supply. The H-1B registration process will start March 1st of 2023. It is important that employers and individuals have strategies to approach the H-1B lottery, as well as to make plans for what happens if cases are not selected for H-1Bs in this coming year. At Graham Adair, we're available to help with strategies both before and after the lottery, and to look for alternatives that will help companies retain employees here in the United States.
Hi everybody, I'm here to talk about the long processing times of perm applications. As you all know, this is the first step in the long green card process. Perm processing times have been increasingly longer every month. As of October 2022, the average processing time for all perm applications is 249 days. This time does not include the time taken if there is a perm audit. If there is a perm audit, the time increases by an additional 119 days. Currently, DOL is processing perm applications submitted in February 2022. Now I'm going to go over the steps involved in the perm process and take you through the timelines in each of the process. Firstly, the prevailing wage request. This is the first step in the perm process, and to obtain this from the Department of Labor is currently taking an approximate 7 to 8 months. Currently, DOL is processing requests submitted in April 2022. The second step involved in the perm process is the recruitment phase. This again has two parts. First is the job posting. This is for a period of 30 days. After this, there is a cooling off period for another 30 days. So at a minimum, we're looking at 60 days for the recruitment. Lastly, which is known as the perm certification phase, is where we submit the ETA 9089 application to the Department of Labor. And this, unfortunately, is taking 1 year without an audit. And if there is an audit, it could take longer. So to conclude, it is imperative that your employer starts your perm process early and also consults with an immigration attorney to strategize your case so as to avoid any delays during this long process.
I will be discussing the rise of remote work and the effect of relocation. We're seeing that employers are continuing to allow their employees to work remotely, including from locations that are not near their offices. This raises important questions relating to foreign national workers in the U.S. In terms of non-immigrant visas, the H-1B and E-3 visas are the most restrictive on changes in worksite location. Employers are required to file amendments when there are material changes to the H-1B holder or E-3 holder's work conditions, such as relocation outside the area of intended employment. If required, the amendment must be filed prior to the change in work location. Amendments are not always required if the relocation is within normal commuting distance of the original place of employment. In that case, LCA notices must be posted at the new work location. Moving on to the green card process, the first step for most employment-based foreign national workers is the perm process. The perm is also location-specific. Moving to a different primary worksite or switching to fully remote work may require the filing of a new perm. However, the filing of a new perm is not always required. For instance, the following scenarios may not require the filing of a new perm. First, if the employee's work location changes but is still in close proximity to the original work location. Second, if the employee's perm lists an option to work remotely. Lastly, if the employee plans on returning to the work location listed in the PERM by the time their green card is issued. Companies must ensure that adequate notice is given before a move or a change in work location occurs, so that a qualified immigration attorney can assess whether there is an impact to the employee's immigration processes.
The other thing we're likely to see as the economy improves is increased demand on recruiting departments dealing with new applications. A lot of those applications may require immigration sponsorship, and so we always recommend as a law firm that staffing departments involve their immigration attorneys in the hiring process through candidate screenings. What we don't want to see is a surprise down the road where an offer is made and acceptance is made and we find out the individual is not a good candidate from an immigration perspective, either because they don't have a status that can be extended or transferred, and the company has to start over finding new candidates. So we always recommend that recruiting departments involve their immigration attorneys early on when they deem someone as requiring immigration sponsorship.
I'll be discussing the potential effects a declining economy could have on immigration processes. First, a dwindling economy may result in mass layoffs, which has implications for foreign nationals. Foreign nationals in certain non-immigrant statuses will be entitled to a 60-day grace period if they are termed before their I-94 expires. During this grace period, they can either change to a new employer, change to a different non-immigrant status, or depart the United States. Layoffs can also affect the green card process. If an employee is termed during the PERM process, which is both employer and position specific, the labor certification becomes null and the process must be restarted with a new employer. If the foreign national has an approved I-140 petition but then is termed before the I-45 is filed, the foreign national will need to find a new employer to start the PERM and I-140 processes over again, but they will be able to retain their original priority date. If the I-45 application has been filed and pending for at least 180 days when the foreign national is termed, they can port the application to a new employer if it's in a similar position by filing Form I-45 Supplement J. If the economy experiences a downturn, we may also see a decrease in immigration budgets. Carefully reviewed immigration policies can mitigate the effects of a reduced budget. For example, confining immigration sponsorship to high-level positions instead of entry-level positions that require a lot of training, or no longer paying for premium processing for eligible petitions or dependent applications. Companies can also conduct internal audits to prioritize individuals' green card processes based on their current non-immigrant status and timing issues. The last areas of concern are H-1B benching and salary reductions. Benching occurs when an employer places an H-1B employee in unpaid, non-productive status in violation of federal law. Employers who bench their employees face potential penalties, including civil fines and a ban from participating in the H-1B or other programs. They are also subject to potential lawsuits from H-1B employees wishing to seek lost wages. When considering salary decreases in lieu of layoffs, employers must comply with federal regulations, particularly those that relate to H-1B and E-3 employees. A reduced salary of an H-1B or E-3 employee must still meet the prevailing wage listed on the LCA. Alternatively, employers can file an amendment petition to change the foreign national's employment status to part-time or terminate the employee. But in no case should the employer reduce the base salary below the relevant LCA prevailing wage. For more information about the topics we covered today, please see our article on our website, gramadare.com, and it's also posted on our LinkedIn page. Or you can email us at info@gramadare.com for any questions you may have.